So the book is a compilation of different chapters contributed by 30 different authors, all criticizing or praising one aspect of the Federal Arbitration Act or the Act as a whole. The impetus for writing the book came about because the Act was passed in 1925 by Congress, which is 100 years ago. And a centenary is a good opportune moment to take a step back, examine a statute that has impacted so many lives in this country, and think about ways to give legislators a roadmap for reform. The Federal Arbitration Act is a statute that was passed by Congress to put arbitration agreements on equal footing with other types of contracts. The 100th anniversary of the Act provided an opportunity to look at some of the criticism that already exists that has been building, I would say, over the 100 years, but mostly since the mid-1980s when the Supreme Court decided a number of cases that made it clear that statutory rights still could be arbitrated, that consumers and employees, even if the agreement to arbitrate was part of an adhesive agreement, meaning a take it or leave it agreement, that those consumers and employees had no recourse to the courts. And there was some view that that was, in essence, suppressing claims because very few consumers and employees knew about arbitration, could afford to go forward with arbitration, and so ended up not bringing claims that they might otherwise have had up against corporations and other companies. My co-editor, Rick Bales, who is a professor at Ohio Northern University, is an expert in labor arbitrations. I had more of an expertise in commercial and securities arbitration, so we paired up together to bring our respective expertise to the table so that we can cover all kinds of arbitration that's governed by the Federal Arbitration Act. So we have 30 contributors to our 32 chapters, and it turned out almost everybody had a different idea about how to reform the FAA, either to substantively make it more fair to those people who ordinarily we wouldn't have thought would be covered by the Act, but also on some technical points. There's some procedural devices, as I mentioned, in the Federal Arbitration Act, and some of them really need to be updated for a more modern kind of arbitration. Or there are gaps in coverage that many have thought, well, it's time for Congress to fix these gaps, close some of these holes. So policymakers should really be able to balance in coming up with reforms of the FAA and upholding arbitration as a valid means for dispute resolution, need to balance that against taking advantage of people who don't have any choice in the matter. I think the book would be really valuable to any policymaker or legislator who is looking to pass some reform of the arbitration statute. In addition, scholars of arbitration who are considering ways to improve the arbitration law in this country should be reading the book and would be interested in it. And any student of arbitration who wants to better understand the statutory framework of arbitration would find the book valuable.